Hello, good afternoon, and welcome to Edwin Co's webinar on data privacy and Brexit. So very topical. My name's Nick Phillips. I'm a partner in the IP team at Edwin Co, and this is my colleague Selina Clifford, who is a senior associate in the IP team. So we're going to be talking to you, chatting with you for about somewhere between 45 minutes and an hour. What we'd like to do is try and take some of your questions on the way through. So there is the facility in this GoToWebinar app to ask questions. So please do ask questions, and we'll try and either take those on the way through if they're relevant to a particular topic, or if we have time, we'll try and take them at the end as well. So do put some questions in. So the idea of this session is that by the end, either you will have a better idea of what you need to do to get ready for Brexit from a data privacy point of view, or alternatively, hopefully, I suppose, you will just go away thinking, I've done everything, I'm completely ready for Brexit, and nothing more to worry about. So let's see how we get on. Cool. So let's try and make this as practical as possible. So I've put up just to start with as a little case study. Not going to go through it in any detail, but really everything we say, we're going to try and relate back to what we hope would be a fairly sort of typical UK-based business. So we're going to try and think about a UK-based business which either is a pure UK business, so no sort of contacts or customers or suppliers outside the UK. But we're also going to think in terms of a UK business, perhaps which has customers in the EEA in Europe, or has suppliers, or even an office in Europe. So we're going to try and relate back to this case study in whatever we're saying. Right, so where are we? I mean, as I'm sure you all know, 31st of January 2020, the UK formally left the EU. So we Brexited on the 31st of January. And then really since then, since the 1st of February, we've been in this transition period, also referred to as an implementation period. And really and truly, everything has stayed the same in that transition or implementation period. So as far as UK business is concerned, you really wouldn't have noticed the difference. Everything has continued. But then the big change which is coming along, 11 p.m. 31st of December, that's when we sort of properly leave the EU. I have to say that date is rushing up on us. It's just over 3 weeks' time, so quite a lot to do. Hopefully you've done quite a lot of things already. And just in case you're reading any sort of government literature, any government press releases, that date is quite often referred to as IP completion day, which is a bit terrifying if you're an IP lawyer, but stands for implementation period completion day. So look out for that phrase whenever you're reading anything. This is possibly a Edwin Co lawyer trying to work out what's going on with Brexit and what's going to go on at IP completion day. But there are lots of issues here for businesses, and businesses are worried. So it is important that you have a good think about what you're doing in preparation for Brexit on the 31st of December. IP completion day, so 31st of December. What happens? Well, a bit of a disclaimer here. I mean, we are law firms. We have to disclaim things. It's not completely clear at the moment. So as you will have read, the EU and the UK are still negotiating. They're still trying to do a trade deal. It is likely that if a trade deal is done, and I appreciate that's quite a big if at the moment, that part of that trade deal will include something about data protection. And so some of what we're about to say might change. What we'll do as we go through it is we'll flag the bits that we think are likely to change. We're slightly crystal ball gazing, but my suggestion would be at this time, sort of 3 weeks odd away from IP completion day, is that you kind of assume there's going to be no deal. And so what we're going to say to you now is going to be the position. In terms of our law, the basic thing to note is that the GDPR, which is a regulation, goes directly into our law. Nothing for the UK government to do. If we'd have done nothing, that would have just fallen away and would no longer be part of our law. So certainly on one level, the GDPR sort of does fall away, but what the UK has done is it's implemented a pretty much identical piece of legislation, which I'm going to refer to as the UK GDPR, which will apply in the UK. As I say, it is largely identical to the GDPR that we know and love, the EU version. There's a few little changes, largely around sort of changing the references from EU and Union to UK, but it is certainly on day one, 1st of January, pretty much the same as the EU version. So I think that's probably the first practical point here, just to watch out for that, and we will come back to this a bit later on. But insofar as you have contracts and privacy notices, you need just to watch out for your language. You probably, and again we'll come back to this, but you probably need to be changing your references to EU and to GDPR and to the regulation over to references to the UK and the Data Protection Act 2018. So there's a sort of quite an easy practical point there, but as I say, we'll return to that. So what are we going to talk about today? I've set it out here, so I'm just going to do a little bit now about what law applies. You remember that I've said that there's a UK GDPR and an EU GDPR, so you need to get it right as to which one you're dealing with. Selina is then going to talk about representatives, both the EU representative, and introduce you to the new UK representative. I'm going to talk about data flows, which is possibly the trickiest area, although I probably would say that because I'm going to talk about it. But data flows, which is important, and then we're going to finish off with a little bit of talk about the one-stop shop and some other practical changes that you need to bear in mind before the end of the year. So let's get into it. What law applies? So you'll remember that with the GDPR, the EU GDPR, we've got this sort of extraterritorial provision, this sort of grasping, reaching provision, which is in Article 3 of the GDPR. And basically what it says is that if you are a business which is not in the EU, but you are perhaps selling your goods or offering your goods or services to people in the EU, then the GDPR does apply to you, even though you're not based in the EU. And certainly in terms of our practice, this has come up quite a lot. So mostly when we're advising US clients. So we have quite a lot of US clients who are sitting in the US, have no sort of place of business in the EU, but because of the nature of their business, they are selling their goods and services into the EU, and in those circumstances, we've had to advise them that the GDPR does apply to them. So they've had to comply with the GDPR. So that's the sort of background to that. Now the slightly tricky bit is that because the UK now gets its own GDPR, we have a UK GDPR and an EU GDPR in parallel. So if we think about a UK business, so they're established in the UK, so the UK GDPR will apply to them for all sorts of, for any kind of data processing they do. But if that UK business is offering its goods or services to people in the EU, or it's monitoring the behaviour of people, perhaps it's looking at sort of buying preferences of people who sort of people on the internet in the EU, then it will also be governed by the EU GDPR. So as a UK business, you may well be subject both to the UK GDPR and also to the EU GDPR, which I think probably on day one is not so much of an issue, because as I said, the UK GDPR and the EU GDPR are going to be sort of largely the same. But what we might expect to see, certainly over time, is there to be a bit of divergence between what the UK does and what the rest of the EU does. So you need to keep an eye on that, because that could end up being a little bit problematic.
Thanks, Nick. We've actually had a good question in that I think is worth asking here, if that's okay. Someone has asked, does that mean I might be fined under both the UK and the EU GDPR? Just wondering whether you could pick that up here.
Yeah, that's a good point. I think the answer is potentially yes. So I suppose if you think about a UK business, as I've said, will be subject to the UK GDPR. But if they're the sort of business, and I suppose I'm thinking about maybe like an e-commerce business, which has customers in the UK, but also has customers in the EU. So perhaps they've got a database which consists of both that UK data and that EU data. If there's a security breach, they would potentially be dealing with both the UK's ICO and also the sort of EU equivalent. So potentially, yeah, very much so. They would be liable to fines both from the EU and from the UK. So yeah, I'm afraid that is the new reality.
Okay.
So I'll hand over to Selina for a little bit about EU representatives.
Perfect, thanks, Nick. Yes, so I'll be talking about the requirement for businesses to appoint a representative under the EU GDPR, as well as the UK GDPR at the end of the transition period. So the primary role of a representative is to act as a point of contact for both supervisory authorities and data subjects. Under Article 27 GDPR, organisations not established in the EEA are required to appoint a representative in an EEA state if the organisation monitors the behaviour of individuals in the EEA, or if it's apparent that the organisation intends to offer goods or services to individuals in the EEA. Therefore, from the 1st of January 2021, UK businesses that do not have an establishment in the EEA and who are offering goods and services to individuals there, or are monitoring the behaviour of individuals in the EEA, will be required to appoint a EU representative under the EU GDPR. Now, this representative will need to be established in the EU or a EEA member state, where some of the customers whose personal data is being processed are located. It is important to note, however, that not every business will need to appoint an EU representative. You will not need one if, for example, you are a public authority, or you have a branch, office, or other establishment within the EEA, or your processing is occasional and does not involve the large-scale use of special category or criminal offence data, and the processing is of low risk to the data protection rights of the individuals. Next slide. So what are the rules if you do not have an establishment in the UK, but you are either offering goods or services to people in the UK or monitoring the behaviour of people in the UK? Well, in this case, because you do not have a base inside the UK but are doing business within the UK, you will need to appoint a UK representative under the UK GDPR. It follows from this that if you're not established in the EU or the UK, so for example, you are a US business and you are offering goods or services to individuals in the UK and the EU, then you will need to appoint both a UK representative and a EU representative. The requirements of appointing a UK representative and under the UK GDPR mirror the requirements under the EU GDPR. So we'll look at these next. So what do you need to consider when appointing a representative? Firstly, you should assess your current and future business operations and consider whether you will need a UK representative, an EU representative, or perhaps even both. Whilst appointing a UK representative is fairly straightforward in terms of where they're located, the position is different for an EU representative, which could be located in any EU member state. Ideally, EU representatives should be set up in the EU or EEA state where some of the individuals whose personal data you are processing are located. If these individuals are located in multiple countries, you may need to make a choice about where to appoint a representative. The EDPB guidelines state that if a significant proportion of individuals are located in one member state, it is best practice to appoint a representative in that member state. However, it may not always be an obvious choice, and there may be other factors to consider, such as ensuring a representative is easily accessible to individuals in all countries and has the ability to be able to communicate in a language used by the individuals and the data protection authorities in each of those countries. Therefore, you may need to carry out a business and legal analysis to assess whether a representative can most effectively fulfill their role. Lastly, you must consider the capacity of the representative to perform their primary functions, and that is to facilitate the communication between you and the data subjects and to liaise with the relevant data protection authorities. The representative is also required to retain a local record of processing activities and to provide this record to the data protection authorities when requested to do so. The appointment of your representative must be in writing and should set out the terms of your relationship, and often in practice this is done under a simple services contract. But please note, when you appoint a representative, this does not affect your own responsibilities or liabilities. It simply gives the regulators and data subjects a point of contact should they need to engage with you. Finally, you are required to provide details of your representative to individuals whose personal data you are processing. So this can be done by including the representative's details in your privacy notice or in the upfront information you give to individuals when you collect their data. You should also make this information easily accessible to supervisory authorities, for example, by publishing the information on your website.
Thanks, Selina. There's a few questions coming in. Let me just pick one or two for you. This is quite a good one actually, and one I've had before. So the question is, can my UK or EU representative and data protection officer be the same person?
It's a good question. The general view of the EDPB is no. These are different roles, and therefore there is a risk of conflict of interests if the same person does both. So generally the answer is no.
Okay. All right. Let's move on to data flows. So this is, I think this is probably, to my mind anyway, this is the sort of big area of potential change, and the big area which UK business really does need to have a serious think about. So the basic position has always been that any transfer of personal data outside of the EEA is a restricted transfer. So if you're looking to move data perhaps to the US, or you're looking to move it to Australia or any other country outside the EEA, that's a restricted transfer. And if you want to make a restrictive transfer, you've essentially got three ways to justify it. And we're going to talk a little bit more about these ways, but they are essentially if you transfer to a country which has a finding of adequacy in its favour, then you can do it. So if it's a country which the EU has decided gives an adequate level of protection, then that's fine. You can go ahead and make your transfer. If there's no adequacy decision in favour of the country that you want to make your transfer to, another alternative is to put in place an appropriate safeguard, and I'll come back to that in a second. And then, so as kind of third best, if you like, there are other exceptions or derogations that you might be able to use to allow that restricted transfer to go ahead. So how does all that change with Brexit? The big change is that after the 31st of December, the UK essentially drops out of the EU and becomes a third country. So what that means in practice is that transfers of data certainly to the UK from the EEA will become restricted transfers, and I'll come back and talk about how you need to deal with those as UK businesses in a second. So that's transfers from the EEA to the UK. Perhaps you've got some data hosted in a server based in Germany or in the Netherlands. How are you going to get that data back now that it's a restricted transfer? We'll talk about that in a second. What about transfers of data from the UK out to the EEA? So that's also a restricted transfer, but the UK has said, the UK has made what they describe as a provisional finding of adequacy in favour of the EEA. So the UK has said that essentially the EEA has an adequate level of protection. So what that means in practice is that you can transfer your data from the UK out to the EEA without needing to do anything else. It's okay because it's been found to be adequate. So that's good. That's one less thing to worry about. And then transfers of data from the UK to other countries, so to non-EEA countries, they're also restricted transfers. And so, but the thing to note is that there's 12 countries in relation to which the EEA has made a finding of adequacy, and they're countries such as New Zealand, Israel, Argentina, Uruguay, and there's partial findings in relation to Japan and Canada. So in relation to those, the UK has sort of provisionally recognised those findings of adequacy. So if you are wanting to transfer your data from the UK to Israel or to Argentina or to Uruguay, then it's fine because you've got that finding of adequacy in place. For other countries, so countries where there's not a finding of adequacy, you've got to find a different way to do it. So let's look first at transfers from the EEA to the UK. Now, obviously, this would be very much simpler if the EEA or if the EU recognised the UK as having an adequate level of protection. And this is the area that may well change depending on whether the UK and the EU end up doing a trade deal. And this is a slight bit of speculation, but it's sort of speculation that a lot of people seem to share. And the speculation is that if there is a trade deal, sort of tacked onto that will be a provisional finding of adequacy in favour of the UK. So it's a kind of watch this space type thing, but the general feeling is that the UK will get a finding of adequacy if there's a trade deal. it may not do, and of course there may not be a trade deal. So I think what we should do for the rest, well, what I'm going to do for the rest of this this session is just to assume no trade deal and no finding of adequacy. Obviously, if there is, then that's a real bonus, because it removes a headache for a lot of UK business. But let's press on and assume no finding of adequacy in favour of the UK. So you're left with putting in place appropriate safeguards, or relying on one of the derogations, and I'll come back to what those appropriate safeguards look like in a second. In terms of derogations, I think it's just important to say that this is very much the sort of last chance saloon, last resort. You really shouldn't be relying on these, as of course the European Data Protection Board, GDPR, has consistently said this really is last resort stuff. They tend to be restrictively interpreted, and they're certainly not for sort of regular flows of data. So if you've got a data center based in Germany or the Netherlands, and you're continuously accessing it to get your data out, this is very much not for you, and it's very much for the occasional and non-repetitive transfers of data. But so I would always look first at adequacy, and then I would look at appropriate safeguards. And it's only really if I can't get one of those that I'm looking at derogations. I've tried to summarize some of the derogations there. The first one is consent. I mean, as you'll probably all know, consent gets a fairly high bar in the GDPR, and explicit consent an even higher bar. So I must say, in my experience, I've rarely seen consent used as a derogation. But I suppose it's a possibility. But I think I would say it's very difficult to take advantage of. And then the other ones there are really based on necessity. So important to emphasize, this is not just because it suits you. So it might suit you to have your data hosted in Germany or in the Netherlands, but it's certainly not necessary to do so. So it might suit you to have your payroll administered somewhere else, but it's not necessary to do so. So it's straight away, it's difficult to get yourself within one of these derogations. In terms of what we see, it's really the first two, which are the most. I do apologise about the dog. This always seems to happen to me, but he's about to bite the DHL delivery man, I think. It's the first two that we really see. So these relate to contracts, really one-off contracts. So if data needs to leave the EU to fulfil a contract in which the individual is party to, or in the individual's interest, then we do occasionally see the use of these derogations then. But that's pretty much it, really. And the other three I've put down there, they're fairly rarely used, and I won't spend any time on those. So if we move on to safeguards, I've put a few down there. Realistically, if you're coming to this now and you're looking at putting in place a safeguard to get data from the EU to the UK, so assuming no finding of adequacy, essentially the only safeguard in town is your standard contractual clauses. The rest of them won't work for various reasons. The binding corporate rules, they're pretty good, but they're fairly complicated, and they are fairly long-winded to set up. You're really looking at 12 months plus to put in place a set of binding corporate rules, which would typically be a sort of a set of rules which govern the handling and transfer of data, perhaps between the companies in a group. So worth bearing in mind for the future, but not something you can do quickly. Privacy Shield has gone. You may have read about the Schrems 2 decision. So Privacy Shield was a way of transferring data from the EU out to the US. So it was an additional safeguard available to US businesses, but it was held to be invalid by the European Court, by the CJEU. And we'll come back to that a little bit later when we talk a little bit more about Schrems 2. And then approved certification mechanisms and approved codes of conduct. Well, they're in the GDPR, and they may come into play a bit later. And certainly the UK may now start looking at either approved certifications or approved codes of conduct. But at this moment in time, there's nothing available. They just don't exist at the moment. So all of that does rather throw you back to your standard contractual clauses. Now, what standard contractual clauses are, they literally are what they say on the tin. They are a set of standard contracts which have been approved by the EU Commission. And what you do is you put that contract in place between the business which is exporting the data. So if it's a business in the EU, you put it in place between that data exporter and the data importer, which might be, following the 31st December, a business in the UK. And by having that contract in place, you kind of guarantee as an adequate level of protection. If I'm honest, they're not ideal. They are old. So the newest one is just over 10 years old. So it predates the GDPR, which I always think is slightly bonkers, but that is the case. They're slightly inflexible. You can't really amend them. It's certainly very difficult / impossible to do anything with more than sort of 2 parties. So if you wanted to do a 3-party agreement, that doesn't really work. And they also only really apply to a couple of limited situations. So they only apply where you're transferring data between 2 data controllers, or where you're transferring data between a data controller and a data processor. So what they don't cover, which is always a problem, is the situation where you want to transfer data back from a processor, so maybe a data center, back to the controller. And also they don't cover the situation where a processor wants to use a sub-processor. So they don't do sort of what I would describe as P2C, processor to controller, and they don't do processor to processor or processor to sub-processor. And what tends to happen in practice is people just sort of adopt either the controller to controller form or the controller to processor form, and even if that doesn't quite fit the facts, the general feeling is that it's better to do that than to do nothing. So yes, that's standard contractual clauses, and that is really your option, and that is really what you need to be thinking about doing if you want to be moving data from the EU to the UK, and similarly if you want to be moving data from the UK to sort of non-EU countries. So with that sort of slight law lecture, I'm going to turn it over to Selina to try and put it into perspective, or put it into sort of some sort of practical form, how that really works for UK business. So I'll leave you with that unenviable task, Selina.
Thanks, Nick. Yes, so next I'm going to take you through some practical scenarios on data flows after the transition period has ended and what you need to do. So in the first scenario, if you're purely a UK business, meaning you are not transferring data in or out of the EEA, then there's nothing you need to do. There's no transfer of personal data. If you're a UK business that is sending data to your suppliers who are located in the EEA, then at the end of the transition period, this transfer would be subject to the transfer rules in the UK GDPR. So the UK government has confirmed that when the transition period ends, there will be a transitional provisions for a UK adequacy decision to cover transfers of data to the EEA. Therefore, UK businesses transferring data to suppliers based in the EEA will be permitted. It's always important to consider the return flow of data and whether or not you will be receiving personal data back into the UK. Data that is transferred from the EEA to the UK will be a restricted transfer under the EU GDPR. So unless a derogation applies or the UK gets an adequacy decision, you would be required to put appropriate safeguards in place to govern the return transfer of personal data back into the UK.
Just to stop you there, Selina. I mean, that's quite an important point. And just looking at just sort of flicking through the questions, of which there's now quite a few. Certainly a common theme when it comes to data flows is a UK business perhaps using either a website host or some sort of data host in the EU, and I think can't really emphasize enough that the transfer out to that EU website host or EU data center is absolutely fine. The UK government has said that EU is adequate system of laws, so no problem, but it's getting it back which is problematic. So you're going to want to get your data back. So you are going to want to put a safeguard in place to ensure that you can get that data back. Probably just worth saying that in that sort of scenario, it really is the EU businesses' responsibility to ensure it can get that data back. But obviously that doesn't help you as a UK business. If your data gets stuck in the EU, you can point as many fingers as you like. So it really is in your interests to at least reach out to your EU supplier and make sure they're comfortable that they can comply with EU law and, most importantly, practically get that data back to you. Sorry, Selina, I'll let you carry on.
Thank you. So moving on to the third scenario then. The third scenario concerns a UK business who has engaged suppliers based outside of the UK and the EEA. Restricted transfers from the UK to countries outside the UK and the EEA will be subject to transfer rules under UK regime. The UK transfer rules will mirror the current GDPR rules. As such, UK businesses will be able to rely on the same mechanisms as those available under the EU GDPR. So this means you can make a restricted transfer to a country that has an adequacy decision. Note here that the UK government will recognise existing EU adequacy decisions and has the power to make its own adequacy decisions from the 1st of January 2021. Secondly, where you've implemented appropriate safeguards, so Nick spoke about standard contractual clauses being the key method here. And it's also worthy to note that the UK government will recognise has confirmed that it intends to recognise approved EU standard contractual clauses and BCRs where it can. And lastly, that if there's an exception that applies, then you'll be able to rely on that also. In the next scenario, if you are a UK business but have offices around the world, so here, I think we just need to remember that any transfer outside of the UK will be a restricted transfer. This is therefore really a question of working out what your data flows are. So if, for example, you are transferring data from the UK to an office in a country like Argentina or Uruguay with the benefit of an adequacy decision, then nothing further really needs to be done. If, however, you have an office in the US which you transfer data to, you will need to put in place a safeguard before you make that transfer. In terms of transfers going the other way, so from an office in Argentina or Uruguay to the UK, that is also likely to be okay because those countries recognise the UK as having an adequate level of protection. For other countries, however, you will need to look at the local law and see what they say about transfers out of that country. So finally, in the last scenario, you are a UK business with customers around the world. I think the advice is very similar to scenario 4. Again, you need to work out whether you are making a restricted transfer of data. So if, for example, you have a travel agency business in the UK with customers all around the world, and as part of that business, you book hotels for those customers in countries outside of the EEA, the transfer of data to those hotels will be a restricted transfer. So if there's no adequacy decision that has been made about that country, you will generally need to ensure a safeguard is in place. However, for one-off transactions, you may be able to rely on a derogation. So for example, here, you might be able to say that sending data to the hotel was necessary to perform a contract.
Okay.
Next slide.
1 second, hang on, there we are. Right, so all of that was obviously very, very easy. This is very much where it gets more difficult, and so I wanted to sort of tell you a little bit about Schrems 2 and its impact on standard contractual clauses. It's a lot of people have written quite a lot on Schrems 2 and what it means, so I'm not going to spend a huge amount of time on it, but I think it's important that you are at least aware of it and aware of what it might actually mean in practice. So Schrems 2 was a legal case brought by a privacy activist called Max Schrems, and the outcome of the Schrems case was that Privacy Shield, which I mentioned before, which was this sort of safeguard for transferring data from the EU into the US, was ruled to be invalid by the European Court. So it was essentially struck down by the European Court, and it was struck down essentially because of the US's mass surveillance laws. So essentially what the EU was saying was that Privacy Shield by itself cannot guarantee an adequate level of protection for data in the US, because the US government have such stringent powers. They can always come and have a look at that data. So very bad news for US companies. So it's struck down Privacy Shield. That case also went on, had a look at standard contractual clauses, which is why I'm talking about it now, which is why it's so important. The good news is it said that standard contractual clauses are not invalid, so we continue to use them. But what it said was that you need to be careful when you're using them. So essentially, standard contractual clauses may not be enough by themselves to guarantee an adequate level of protection. You may have to do something else in addition to sort of supplement or add to that protection that the standard contractual clauses are giving you. So in many ways, you kind of should have been doing this already, because this is the whole point behind standard contractual clauses. But the effect of Schrems 2 is to now make that a real obligation, something you really must do. Now, I think the best way of looking at what that really means in practice is to have a look at the EDPB's recommendations, and I've put a link to them there, and careful what I say, but actually they're not too bad in terms of reading them. Sometimes you look at stuff from the EDPB and it's fairly impenetrable, but this actually is not too bad. But I've had a go at summarising them on the next slide. We'll just run through those quickly, so you can just get a feel for the sort of thing that we're dealing with. So key to this is just mapping and understanding where your data is going, which really should be doing anyway. Just working out whether your data is moving from the UK to the EU, is it going to the States? You know, what is actually happening with it? So that's pretty fundamental. And then you identify how you're going to do it. So what transfer tool are you using? Are you using standard contractual clauses? Are you using binding corporate rules? So work out how you're doing it. And then you look at what the law is in that destination country. So if you're exporting your data to the US, we know from Schrems 2 that there are some fairly serious heavy-duty mass surveillance laws in the US. So you need to take those into account. Probably worth adding that there are possibly not as heavy-duty and as serious as in the US, but there are some fairly serious stringent mass surveillance laws in the UK, and certainly our investigatory powers legislation does give the UK government some fairly wide powers to sort of look at data and to intercept communications. So there is potentially a problem bringing data into the UK. So it's something you can't dismiss. So having done that, you then identify and adopt what I refer to as supplementary measures. So really supplementary or additional measures which sit alongside your standard contractual clauses or which sit alongside your binding corporate rules. Don't worry too much about procedural steps for now, but then once you've done that, you keep them under review, so you make sure they are still sort of adequate to protect that data. So that's what the EDPB say. One of the key takeouts for me in that is what a supplementary measure really is, and they are classically divided into three. So we have technical supplementary measures, and then contractual and organisational measures. And for me, and I think this is a fairly commonly held view, it's all about the technical measures, quite frankly. So if you can encrypt your data to such a level that the US government or the UK government, even if they do intercept it, can't actually see what's in it, then that's great. That must be good. That must give you that sort of adequate level of protection. Equally, if you can pseudonymize that data, so if you can sort of take out if you can take out the data subjects it's referring to, also that's a big step forward. And what you're aiming to do is be in a position so that when and if it is intercepted by the local government, by the government of the importing country, it means nothing to them. They can't identify the data subjects, or they just can't see it, full stop. So that for me is key. And then you sort of bolster those technical measures with contractual measures. Perhaps you oblige the exporter to be transparent about what its law's like or how many requests it's had in the past, and you get it to reassure you about the technical measures it has in place. And then lastly, you put in place some organisational measures. Perhaps you have some, an overall policy about how transfers are measured, how they're dealt with, and what's done generally if you do get a request from the government, from the local government, to actually see that data. So that's the sort of thing we're talking about. So that really adds a layer of complexity to using any sort of safeguard, not just the standard contractual clauses, but it is something you need to be thinking about, you need to be doing. There is a little bit of a glimmer of hope, or there is a sort of a bit of light at the end of the tunnel, in that very recently, last week I think, the European Commission have published some new standard contractual clauses, which are, I have to say, far superior to what we have at the moment. I've included the link on this slide here, so you can go and have a look at those new standard contractual clauses. So let me just go. Yeah. So I suppose the real drawback is they've come a little bit too late. They've been published for the purposes of consultation. It is a short consultation. I think the consultation expires at the end of this week, and the idea is that all being well, those standard contractual clauses will sort of become law at the beginning of next year, and you'd certainly expect the UK government to adopt those standard contractual clauses, assuming the European Commission does. But realistically, it's a little bit too late for UK businesses who should be looking at putting in place safeguards now, rather than waiting until almost the horse has bolted before trying to put those safeguards in place. And certainly that's the ICO's position, that you should be putting in place the old standard contractual clauses now, and then looking to update them once those new standard contractual clauses do become law. And I think I'm right in saying that it's likely that you'll have a year after those new standard contractual clauses come into force to adopt them, so to put them into place. So it's all a bit, the timing is rubbish. The timing is very unfortunate. So as a UK business, you may well be putting in place an old style standard contractual clause now, and then in the next 12 months, you may well be updating it to incorporate these new standard contractual clauses. But looking at the new standard contractual clauses, they are certainly a lot more robust. They are certainly more flexible. They cover both processor to controller, and they cover processor to processor, which was missing. And they also take into account Schrems 2. So they're not a complete solution to Schrems 2, but as you go through them, they sort of signpost you to things you should be doing to comply with Schrems 2 and to put into place additional supplementary safeguards. So it's looking a little bit easier on the horizon, but as I say, a little bit too late potentially for UK businesses and Brexit. So over to Selina, sort of trying to start wrapping it up, I think.
Yeah, no, absolutely. So moving on, and I guess before Nick summarises the key take-home points, there are some other points for you guys to consider. Firstly, the end of the one-stop shop. One of the key features brought in by the GDPR was the concept of the one-stop shop. The one-stop shop was designed so that controllers and processors in the EEA, which carry out processing that affects individuals in more than one EEA state, only need to deal with a single EEA data protection authority. So if you're currently carrying out cross-border processing, that is, you have an establishment in the UK and another EEA member state, then at present you will be benefiting from the one-stop shop. This means ultimately you are only investigated by one supervisory authority for any infringement or breaches of the GDPR, and would be issued with one fine across the EU for any enforcement action taken. However, once the transition period ends, you may no longer be able to benefit from the one-stop shop. Therefore, you should consider whether your processing activities involves cross-border processing under the GDPR and which supervisory authorities you may need to deal with. So if you have an establishment in the UK as well as in another EEA member state, then you will be cross-border processing. This will stop being cross-border processing once the transition period has ended, and you will therefore need to deal with both the UK ICO and the supervisory authority in the EEA member state. If your cross-border processing is in relation to 3 or more establishments, so 1 in the UK and 2 in other EEA states, for example, France and Italy, then cross-border processing will still apply across France and Italy, but it won't apply with the UK. In this situation, you would need to liaise with the ICO in the UK and also have a lead supervisory authority from one of the 2 EEA member states. Typically, the lead authority would be the member state where you have the largest customer base. If you don't have any establishments in the EEA, but you are providing goods and services to individuals located there, then you will not be cross-border processing at the end of the transition period. However, in this case, you must comply with both the UK GDPR and the EU GDPR, and you may have to liaise with both the UK ICO and supervisory authorities in all member states in which your customers are located. So ultimately, this could mean that you face enforcement action by the UK ICO and each supervisory authority where customers have been affected. Regarding terminology, you should check your existing documentation for references to the EU GDPR and or Union law, and update any outdated terminology to reflect the UK GDPR. Finally, you should ensure that your privacy policy reflects any changes in your processing. For example, you may need to update your privacy policy to deal with existing transfers that will become restricted transfers at the end of the transition period. Or you may need to update your privacy policy to identify an EU or UK representative that you have appointed.
Thanks, Selina. We're very close to the end of our hour, so let me just wrap up with sort of a few final comments and a bit of a shopping list for the sort of things that you need to be doing or thinking about. And then if we have time, we'll try and squeeze in a couple of questions, of which there are quite a lot arriving. So in terms of your shopping list, for the very first time as a UK business, you need to be considering whether or not to appoint an EU representative. And to summarise, if you are doing business with people in the EU, if you're selling goods and services to people in the EU, and you have no place of business in the EU, then the chances are you need to appoint an EU representative. So that is a big change. The second point is you need to work out where your data is flowing. So if it is being moved from the UK to anywhere, you just need to make sure that they will be restricted transfers, and you need to make sure that you have there's either a finding of adequacy or you have an appropriate safeguard in place. And then, as Selina has said, language in contracts and privacy notices, you need to make sure that you are referring to the UK legislation as a UK business, and generally speaking, not the EU business. And then also privacy notices, and Selina's talked about this. This is the thing I'm pretty keen on. It's a very small thing. You know, it's really and truly, you may have to amend your privacy notice to tell people that you have an EU representative, to tell people what your safeguards are and where the data is going. So it can be a bit of a box ticking exercise. But why I say it's important is if I'm supervisory authority, if I'm a regulatory authority, and I'm looking at your business, one of the first things I'm going to do is look at your privacy notice. And if it's all over the place, or if it's out of date, or you're clearly doing business in the EU and you have no EU representative, that's a fairly good signpost to me as the regulator that you're just not complying. I mean, it may not follow that if you have a wonderful privacy notice that you are complying, but it's certainly helpful. And certainly, if your privacy notice is poor or out of date, you may well find it attracts a bit of attention to you. So I think that is important. So I think that is almost exactly our hour. I completely understand if people want to go. There are just a couple of questions that I wanted to just deal with. If you do want to stay on just for a couple of minutes. So the first one I'll ask to Selina, and it's really this question about UK law and EU law. And the question is, should I be referring to UK law or EU law in my privacy notice, or indeed in my contracts?
Yeah, no, it's a really good question, and I guess the answer is it will depend on the processing that you're conducting. It's important to understand the scope of your processing activities and refer to the relevant legislation in your privacy policy as it applies to you. If you're a UK business that operates in Europe or that targets customers in Europe, you will need to apply with both the UK GDPR and the EU GDPR. Obviously, if you are just a UK business with UK-based customers, then the UK GDPR will only apply.
And then the last question, which I'll just pick, I'll pick up. So the question is, if a group which is based in the UK shares data with its subsidiaries, e.g. employee data for employment purposes or customer data for contract reasons, some of which are overseas, do they need to have SCCs between the parent and the subsidiaries? And the answer to that is yes. It doesn't really matter whether that data is going between you and a third party, maybe one of your suppliers or a customer, or whether it's going between companies in your group. Exactly the same rules apply. It's still going to be a restricted transfer. So you need to go through the same exercise, so map those data flows, work out where the data is going, and then work out how you're going to deal with that restricted transfer. Is there an adequacy finding? In which case, great, carry on. If not, think about what safeguard to put in place. As I said, almost certainly standard contractual clauses, and then do this extra sort of Schrems 2 step of thinking about and putting in place additional safeguards, which are likely to split into these technical, contractual, and organisational safeguards. So I'm afraid no distinction moving data around a group as between moving data, to third parties. So there is a bit more for you to do there as a UK business, I'm afraid. So we've overrun very slightly, so apologies for that. I hope that was useful. Hope you enjoyed it on some level. Thank you very much for attending. We will have a look through the questions afterwards, and if we think we can assist, we'll perhaps we'll drop you a quick note. Equally, if there's something you want to pick up, perhaps something which is specific to your business, then please do feel free to reach out to either Selina or myself. But thank you very much for joining.
Thank you.